Hello and welcome to the Herrington Carmichael Employment Law Update for January 2018. First of all, Happy New Year to you all. I hope you have a great and prosperous 2018. As usual, I've got the key employment law updates from the last month to bring to you. This month, though, is a short one. I've only got 3 cases. Let's start with the case involving Morrisons Supermarkets this month and the disclosure of personal data by a rogue employee. Morrisons were held to be liable as a consequence of this employee disclosing large quantities of personal data in relation to its other employees. The unusual point of this case is this individual was acting in a rogue manner. They weren't acting in compliance with normal procedures. They went off and did this, probably maliciously, toward Morrisons Supermarkets, and that resulted in liability for Morrisons. Morrisons are appealing this decision, unsurprisingly, and we have to wait and see what happens with it. But it's a good reminder to employers to make sure you've got your clear processes, policies in place and implemented with your employees in relation to the operation of personal data. This is going to be a really hot topic this year with the inception of the GDPR in May, so please be looking at this. If you haven't taken advice already on GDPR, please come and let us know. Next, the case of Chief Constable and Norfolk versus Coffee. This case involves an employee who had a perceived disability, which was a hearing impairment, which was perceived as continuing and developing. It was found that she was treated less favourably on the basis of that hearing impairment. Now, what's unusual about this case is the perception of the disability rather than the actual disability. Now, in a disability case, there has to be a test as to whether the person is disabled within the terms of the Equality Act, and in this case that was taken and it was found that that perception of disability was still satisfied. This has worked for many years in relation to the perception of other protected characteristics such as sexual orientation, and now we're seeing it developing into the world of disability. What this means is you still have to take care. So you have to take care with employees that are disabled or you may think are disabled in the way you treat them and how you make adjustments for. Finally, the case of Bazarov BJSS. This involves pre-termination protected discussions. Now, normally you would expect that those can't be referred to as part of future employment tribunal proceedings. However, in this case they were, and they were in relation to the issue of what the date of termination of employment was. This is an interesting development because it goes outside of the statutory regime, but what it does do is it means that employers are going to have to be even more careful than you would be normally in relation to conversations you have with employees around termination and making sure that the language is appropriate, making sure that they are scripted correctly in advance, making sure you're going into the conversation in a way that is not going to cause what's called improper behaviour. That's it from me this month. As always, we are available if you have any questions, and I'll come back to you in February. Thank you.